A big day at the Supreme Court with justices ruling on two cases involving President Trump's financial records and tax returns. On the final day of its term, the Supreme Court sending two cases involving President Trump's financial records back to the lower courts. In the case of the Manhattan DA, the justices rejecting the president's claim he has absolute immunity from criminal investigation while in office, and that he may need to comply with the New York grand jury subpoena seeking his financial records. Chief Justice John Roberts, writing in the 7-2 opinion, was also very clear that no one is above the law. Quote, "In our judicial system, the public has a right to every man's evidence. Since the earliest days of the Republic, every man has included the President of the United States." But the justices giving President Trump a chance to raise further arguments in a lower court. And in case involving Congress, another 7-2 ruling, the High Court, reversing a lower court ruling, blocked House Democrats from being able to enforce 4 congressional subpoenas for Trump's financial records. The justices criticizing the lower court for not adequately taking into account the separation of powers and sending it back to them for further review.
This is a political witch hunt, the likes of which nobody's ever seen before. It's a pure witch hunt. It's a hoax.
Democrats on Capitol Hill vow to keep fighting, hoping the documents might shed some light on whether there was any foreign influence over the Trump family business and whether the Trump campaign may have violated campaign finance laws.
The Supreme Court, including the president's appointees, have declared that he is not above the law.
Let's bring in our guest, Jonathan Adler. He's a professor at the Case Western Reserve University School of Law. He also just penned a piece in the Times with the headline, "This is the real John Roberts, a judicial minimist who seeks to avoid sweeping decisions with disruptive effects." And we'll get into the Chief Justice in a little bit. But Jonathan, to today, and before we get to the consequences for the sitting president, now the broader implications are nobody, not even a president, is above the law. And the way the decisions were laid out, and it wasn't 5-4, it was 7-2 in both cases. I know it's a broad interpretation, but it's a fair one, isn't it?
I think it is a fair one. I mean, the court rejected the claims that the president's attorneys made that he was immune from criminal investigation, immune from congressional oversight of his personal financial dealings. And that's important. As the court has reaffirmed in other cases, we have a president, not a king. And ultimately, the president, in his personal private affairs, is like the rest of us. And that means he is subject to criminal investigation. It means that he is subject to investigation for wrongdoing. And the court reaffirmed that principle today.
You know, it's funny. I mentioned the piece you wrote in the Times, which is before these rulings came down today. And it's prescient in that, yes, they were significant, but they were also in some ways unsatisfying because it kicked the can down the road a little bit. And it's seemingly in keeping with the Roberts court, which is, you know, I guess in some ways, if he gets everybody upset, he's doing his job, but it's also maddening in that there isn't clarity. It's getting pushed back down again, whether it be back to New York, we'll get to what's going to happen with Cy Vance's case, or back to Congress with more restrictions. Nonetheless, that's kind of his MO, isn't it?
Well, it is. I mean, this court tries not to decide more than what's right in front of them. And so in the Vance case, the case coming out of the New York grand jury subpoena, the Supreme Court affirmed the lower court, but this was what we call an interlocutory ruling. This was a ruling that had been made by the lower court, rejecting certain objections that Trump had made, but it wasn't the final disposition of the case. And so it goes back to the lower court to continue with its proceedings. In the congressional cases, I think most people recognize that partisanship played a role both in the breadth of what Congress asked for, as well as the extreme degree of resistance that Trump put up to these requests. And the court set out a rule that says, look, Congress has the authority to investigate, but it's not anything goes. And in that respect, that decision was a message both to Congress and to President Trump, that both have to recognize that there are certain rules or bounds they have to operate in.
So, Jonathan, let me do these individually, because on the Vance case, people whom I respect, frequent guests of this program, they disagree with some to say, well, it's a non-starter. This basically means that whatever decisions happen are going to happen after November. Some think it could be expedited in New York. It's not hard here if you have a judge who wants to push this along, let alone a grand jury in New York. It's not going to be hard to basically get what they're looking for the prosecutorial side. Is it possible that Vance gets his hands on these 8 years' returns before November?
I think it's certainly possible. I mean, that really depends on how quickly the lower courts want to move. But I think it certainly is possible. Now, it's important to remember this is a grand jury subpoena. And under grand jury secrecy rules, the grand jury getting the documents doesn't mean they get to be disclosed. And so Vance may get his hands on the documents, may get to see them. That doesn't mean that they would necessarily become public. And an issue that the court did not decide is whether or not the president could be subject to indictment while still in office. I think most observers believe that if Vance pursued an indictment of Donald Trump, that indictment would essentially be held until he leaves office.
And to that end, if you're Donald Trump right now, and I don't want to drag in the world of politics, but they're intertwined here. Let's say the polls are right, and he loses, and he's a private citizen. If Vance all of a sudden brings this against private citizen Trump out of office, he's got a lot of exposure, civilly and even possibly criminally here. That's got to weigh on the president. In some ways, he'd rather know his fate before he leaves office if he wants to use the pardon power.
I mean, he might. I mean, I think we will see what, if anything, the president is willing to do with the pardon power. As I think most people recognize, the pardon power doesn't really have much in the way of limits in that the president can pardon people for self-interested reasons. And if he thinks that the Vance case is going to not merely embarrass him, but could actually expose him to criminal liability, it would not surprise me at all if he used the pardon power, although there's very real doubt that he can pardon himself. As a private citizen, Trump would have both criminal and civil exposure in a wide range of cases, both that are in court now and some cases that have yet to be filed.
Now we get to the case as it relates vis-a-vis Congress. Some have said, and I'm curious if you agree, what the Supreme Court did was, yes, it said that there was too much partisan overreach on both sides, but it gave Congress a roadmap that if they follow and they stay within the lines, in effect, they're going to get these returns. Do you agree with that?
I definitely agree with that. I mean, obviously, it takes time for Congress to do that. But, the posture of this case was Congress said, give us everything. The president said, I'm going to give you nothing. And it went to court on that posture. And what the court said is, look, Congress never gets everything that it wants when it's doing oversight. And those subject to investigation never get to withhold everything, especially the president. Congress, if you are more specific about how the types of information you are looking for relate directly to legitimate oversight functions, legitimate legislation that you could enact, you're going to be able to prevail. But there's no question that the majority opinion that Chief Justice Roberts wrote does allow Congress or enable Congress to get lots of the information it was looking for.
Jonathan, good conversation on a very interesting day on the High Court. I appreciate the time. Up next, we pivot to intelligence, or lack thereof in this case. After the break, the best-selling author who says that President Trump simply doesn't read intel briefings, and furthermore, it's nearly impossible to get his attention to tell him about critical national security issues.